Hello, and welcome to the Society of Construction Law Australia's podcast, the podcast where we look at technical and legal issues facing the Australian construction industry. My name is Melissa Yeo, and I'm one of the directors of the Society. Kindly sponsored by Baker McKenzie, the first SCL event of 2017, held on 8 March in Brisbane, drew a large crowd of professionals practicing in various disciplines in the construction industry. Raisa, Conchin, partner of Wotton and Kearney, together with Elizabeth Conlan, senior associate of Wotton and Kearney, shared their views on how to manage the pre-allocation of risk in the era of proportionate liability. For those of you who could not attend, this episode records Raisa and Elizabeth's key lessons for the construction industry on this important topic. Be sure to subscribe to the Society of Construction Law podcast to be alerted when new episodes are available. We look forward to sharing further podcasts with you. I'm Melissa Yeo. Thanks for joining us. I will now hand you over to Lee Duthie, partner of Baker McKenzie, to introduce our speakers.
Thank you, Melissa. I'm a construction partner here, and welcome to Baker McKenzie. It really is our privilege to host this SOCLA event. We have a long relationship with SOCLA in our 3 offices on the eastern seaboard, Sydney, Melbourne and Brisbane. In fact, one of our construction partners, Alex Hartman, is presenting next week on another SOCLA function, which I saw briefly flash up on the board, dealing with construction waste, which is quite a different topic. I have got no idea how to tweet, so I'm not going to be doing any of that here. Now, my role is to introduce our speakers, and they're sitting in front of me. Raisa Conchin is a partner at Wotton and Kearney, and has practiced in the field of insurance and commercial litigation for over 10 years. She also has a broad expertise in a number of specialist insurance areas, including D&O claims, professional indemnity, involving professional services firms, builders, architects, accountants and such like. Elizabeth Conlan is a senior associate at Wotton Kearney, and her practice similarly focuses on PI, directors and officers liability, as well as insurance advisory work. And before the start here, I did ask a couple of very, very piercing insurance-related questions, which they answered for me. So, look, I'm sure we'll all learn a lot from this, so please take it away.
Hi everyone, my name's Raisa. I think if I press a button we should go to the next slide. Oh, how good's that? Okay. Elizabeth and I have come here tonight to talk to you about proportionate liability, and it's really a topic that has been done to death since it was introduced in Queensland in 2004. I've been to countless proportionate liability seminars. I can't possibly go to another except for one that I am apparently presenting. But today we'll be focusing on a specific part of the proportionate liability regime or a specific facet, which is contracting out of proportionate liability. And Queensland has a unique system in that contracting out of proportionate liability is expressly prohibited in our state. That's not the case in other states. New South Wales, WA and Tasmania, it's expressly permitted, and the other states and territories are silent. And I guess the general view is that it's probably not allowed in those states either. So we'll be focusing on the pre-allocation of risk between parties to a construction contract, and I guess the uncertainty and the confusion that surrounds Section 7 of the Section 7 sub 3 of the CLA in that context, i.e., when am I contracting out? Am I allowed to contract out? And we'll also look at the insurance implications of those issues. It's pretty hard going sometimes getting through this topic. There's quite a bit of content, so we've kept things quite high level and quite practical, and the aim of that is so that you guys get something useful out of today and we can have some questions at the end. So I'll hand over to Elizabeth now.
Thanks, Raisa. The concept of proportionate liability in Australia initially rose out of the movement to revise the law of joint and several liability in the early 1990s, and was later developed as a consequence of the insurance crisis, which resulted from the collapse of the HIH insurance group. Prior to this, joint and several liability most commonly arose in claims for breach of contract and in tort. Any party found to be jointly and severally liable was liable for the whole of the loss, irrespective of the level of that party's responsibility. From a plaintiff's perspective, that was beneficial. The plaintiff could pursue the defendant with the deepest pockets and avoid partial recoveries. Of course, a defendant could pursue another defendant for an equitable or a statutory contribution, but that obviously didn't affect the extent of that defendant's primary liability to the plaintiff. In the early 1990s, several corporate collapses resulted in an increase of professional negligence actions against accountants arising out of their audits of these companies. Although other joint tort feasors, including company officers, were also pursued, they were generally unable to meet their substantial liabilities to these companies. The accountants who had the benefit of substantial insurance cover therefore became the primary targets for recovery. The joint and several liability borne by the accountants left their professional indemnity insurers in the unenviable position of having to bear 100% of the company's loss, notwithstanding the fact that the accountant's responsibility for those losses was, in most cases, very minimal. Those developments became the catalyst for an inquiry commissioned by the Commonwealth and New South Wales Attorneys General, conducted by Professor Jim Davis into the law of joint and several liability in the mid-1990s. And Professor Davis recommended that proportionate liability replace joint and several liability for negligence resulting from property damage and economic loss. In other words, a wrongdoer's liability for loss and damage should be proportionate to the wrongdoer's degree of fault. At this time, the concept of proportionate liability was very much in its embryonic stage. Nonetheless, it caught on in somewhat a limited fashion in the construction industry. The Victorian Building Act of 1993 introduced the first proportionate liability regime in Australia. That regime was limited to actions for damages for loss or damage arising from defective building works, and other states and territories introduced similar proportionate liability regimes to deal with those claims. It was not, however, until the collapse of HIH in 2001 that proportionate liability as a concept really caught on in a more significant way. That collapse, coupled with a reduction in competition in the insurance market and generous awards rendered in personal injury actions, resulted in a substantial increase in insurance premiums. And that crisis led to a package of insurance-driven reforms to the law of negligence, in respect of which proportionate liability was a key component. The Queensland Civil Liability Act of 2003 forms part of those reforms. That regime operates to restrict courts when awarding damages in respect of claims for economic loss and property damage arising out of a breach of a duty of care to amounts which justly reflect each defendant's responsibility. So the CLA, as Raisa was mentioning, has a unique feature which has unfortunately created a great deal of uncertainty in terms of allocating risk between parties to construction contracts, has left gaps in professional indemnity and general liability insurance, and has added to the complexity of defending actions for the benefit of construction professionals and contractors, and this is the express prohibition against contracting out of the proportionate liability regime under Section 7, subsection 3 of the Civil Liability Act. The proportionate liability legislation in New South Wales, Western Australia and Tasmania expressly permit contracting out of their respective proportionate liability regimes, the consequence being that parties can include clauses in their construction contracts which stipulate that the contract is not governed by the proportionate liability regime. The legislation in the ACT, the Northern Territory, South Australia and Victoria are silent, but the general view is that parties in those states can't contract out of those regimes. There is an alternative view to the extent that it couldn't have been the legislature's intention to substantially interfere with private contractual arrangements, allocating risk between parties where there is no express prohibition against contracting out. Section 7, subsection 3 of the Civil Liability Act provides that the Act, other than Chapter 2, Part 2, which contains the proportionate liability regime, does not prevent parties to a contract from making express provision for their rights, obligations, and liabilities under the contract in relation to any matter to which the Act applies, and does not limit or otherwise affect the operation of the express provision. Apart from some very brief consideration by Justice North in the Queensland Supreme Court decision of Ireland and B&M outboard repairs, there's really been no comprehensive judicial comment regarding the scope of this prohibition. Two key approaches, though, have emerged in the commentary. The first being the literal approach, which has been adopted by Justice Chesterman and Jeremy Sweeney of Council. And they suggest that the prohibition has the effect that the proportionate liability regime prevents parties to a contract from making express provision for their rights, obligations and liabilities under the contract. In our respectful submission, that's an extreme view and is likely to produce some commercially very undesirable outcomes. The alternative position is the facilitative interpretation adopted by Ashley Jones. And Mr Jones says that the prohibition allows parties to make contractual provision subject to an exception. It applies only insofar as the proportionate liability regime applies. Accordingly, the prohibition extends to the extent that the contractual term is inconsistent with the proportionate liability regime. In our experience, our limited experience as insurance lawyers, parties to construction contracts in Queensland seek to sort of circumvent a lot of this confusion by adopting certain strategies, many of which I'll go on to discuss a bit later. But for the time being, it's probably useful to highlight two key questions that we generally ask ourselves when confronted with defending a claim brought pursuant to express contractual terms which seek to allocate risk between parties. The first question is the contractual claim capable of being characterised as an apportionable claim under the proportionate liability regime? Now, you'd think that the analysis would end there. The claim is either apportionable or it's not. However, Section 7, subsection 3 prevents parties from pursuing certain non-apportionable claims where the contractual terms pursuant to which the claim is brought breaches or offends the prohibition. So hence we need to go on to the second question, do the terms of the contract pursuant to which the claim is brought offend the prohibition? So turning to the first of those two questions, whether contractual claims are capable of being characterised as apportionable claims. By way of reminder, Section 28, subsection 1A of the Civil Liability Act defines apportionable claim to include a claim for economic loss or damage to property in an action for damages arising from a breach of a duty of care. Now, as we know, most construction contracts contain strict contractual obligations, the effect of which is that if the contractor fails to comply with those obligations, the contractor will be held to be liable for breach of contract, whether that breach arose as a consequence of any breach of duty on the part of the contractor. A good example of this is a warranty that the works will be fit for purpose. A question therefore arises whether claims for breach of these sorts of contractual obligations will constitute an apportionable claim. If the answer to that is yes, then the operation of Section 7, subsection 3 becomes irrelevant or academic. There are three distinct approaches to answering this question. Unfortunately, it's not an easy question to answer. The first approach is that the proportionate liability regime only applies to a contractual claim where the relevant breach is a breach of a contractual duty which is concurrent and coextensive with a duty in tort. And that's generally consistent with the language of the Act and also the Queensland Supreme Court decision of Hobbs Haulage and Southside Proprietary Limited. The second approach is that the proportionate liability regime applies to claims for breach of a strict contractual obligation provided the act or omission which gives rise to the breach of contract factually arises from a breach of duty. And that is supported primarily by the New South Wales Supreme Court decision of Reinhold and New South Wales Lotteries Corp. The third approach is that the proportionate liability regime does not apply to pure contractual claims at all, and that's supported by the Victorian decision of Lawley. Now, although we understand the merits of the second approach in that it prevents a plaintiff from crafting its claim to get around the proportionate liability regime, we think it's gone too far in the other direction, in that it seeks to effectively turn pure contractual claims into effectively negligence claims. We consider that the Queensland courts are more likely to adopt the first approach, as I said, because it's generally consistent with the wording of the Act, and the first case on point in Queensland, Hobbs Haulage, tends to adopt that approach. So, turning to the second of the two questions, being that if the contractual claim is not capable of being characterised as an apportionable claim, do the terms of the contract pursuant to which the claim is brought offend Section 7, subsection 3? And in order to address this question, we need to look at some of the common mechanisms used to allocate risk between parties to construction contracts. Now, as you know, there are plenty of mechanisms to do this, but I'm just going to focus on 4. So the first being a clause specifically contracting out of the proportionate liability regime. You might see this type of clause in contracts where the governing law of the contract is, for instance, New South Wales, but you almost certainly won't see it where the governing law is the law of Queensland, and for good reason, because this type of clause will almost certainly offend Section 7, subsection 3. The second is a term pursuant to which parties agree to bear loss in specific proportions or to be jointly and severally liable. And again, this type of term may also offend Section 7, subsection 3, because it seeks to usurp the court's role in terms of apportioning liability for loss under the proportionate liability regime. The third mechanism is a term that nominates the governing law of the contract to be the law of a state, which permits contracting out. And these terms are often accompanied by indemnities and clauses specifically contracting out of the specific proportionate liability regime. This combination of terms is unlikely to offend Section 7, subsection 3, as long as the choice of law provision is upheld. So, for instance, if the construction project is based in Queensland, all of the parties are based in Queensland, and the only reason the parties choose the law of New South Wales is to circumvent the effect of the proportionate liability regime in Queensland, then the choice of law provision will probably be set aside, and the contracting out provision will likely offend Section 7, subsection 3. So the fourth mechanism, and probably one of the more interesting, contractual indemnities. And based on the material that we've already presented, allocating risk by way of contractual indemnities is likely to be a fairly uncertain exercise in Queensland. The general conditions of contract under the Australian standards in this slide contain fault-based indemnities, the terms of which you're no doubt all aware. These indemnities These are indemnities given by Party A to Party B in respect of claims for loss or damage to property arising out of work done under the contract, but the indemnity is reduced proportionately to the extent that the acts or omissions of Party B cause or contribute to the loss. So on their face, these indemnities appear to be consistent with the rationale of the proportionate liability regime. However, when you consider them more closely and consider how they may be applied, they have the potential to offend both Section 7, subsection 3, and also Section 32A of the Civil Liability Act, which I'll discuss in a minute. Section 7, subsection 3 will generally be more relevant where you're challenging the validity of primary claims to enforce indemnities, where the purpose of those indemnities are to evade the operation of the proportionate liability regime. Section 32A, however, is more pertinent in terms of challenging cross-claims between defendants for contribution or indemnity, where such cross-claims are being made in respect of apportionable claims. So Section 32A provides that a concurrent wrongdoer against whom judgment is given in relation to an apportionable claim cannot be required to indemnify another concurrent wrongdoer. So it's axiomatic that where a judgment has not occurred, the provision shouldn't apply. However, if we look at a scenario in which these types of indemnities may become relevant, we can see that Section 32A is unlikely to have such a narrow application. So let's say that a property owner contracts with a head contractor to design and construct a commercial building with a couple of levels of basement. The head contractor subcontracts an engineering firm to undertake design work and a construction company to complete construction. The design of the basement includes a retaining wall. The construction company constructs the retaining wall. During the course of construction, a weather event occurs. An inundation of stormwater to the back of the wall causes the wall to fail, which in turn causes a failure of support of the land and damage to a building on an adjacent property. The adjacent property owner sues the head contractor, the engineering firm and the construction company in negligence, alleging that its loss and damage was the consequence of both design and construction of the wall. Now, the contracts between the head contractor and the two subcontractors contain the type of fault-based indemnities that we've just been discussing in favour of the head contractor. The head contractor naturally will want to pursue cross-claims against the two subcontractors to enforce those indemnities. Section 32A, however, is likely to eventually make those cross-claims unsustainable because each of the adjacent owners' claims are apportionable. Each of those claims are to be decided in accordance with the proportionate liability regime. If the court apportions liability between those parties and renders a judgment, then Section 32A effectively thwarts the cross-claims. Of course, if both apportionable and non-apportionable claims are advanced against the defendants, the CLA does not prevent the defendants from pursuing cross-claims for enforcement of indemnities and breach of strict contractual obligations in respect of the non-apportionable claims. Unfortunately, there's no easy answer and no easy way of determining whether an indemnity is likely to offend Section 7, subsection 3 or 32A of the Civil Liability Act and the extent to which those terms will ultimately be enforceable. We can take some heart, however, that if such terms prove to be unenforceable, that there's nothing in the Civil Liability Act which prevents the court from considering the apportionment of risk under the contract for the purposes of apportioning responsibility under the proportionate liability regime. Indeed, the Queensland Court of Appeal decision in Kem and Cole would suggest that the court is obliged to do so. So I'll now hand over to Raisa to discuss the insurance implications of these issues.
Insurance implications. So, typically in the construction space, we see two types of policies. I'm not going to discuss things like contract works and project-specific insurance, but let's just start with the basics of a professional indemnity policy and a general liability policy. A professional indemnity policy is a specialist type of liability cover. It responds to claims against professionals. And one of the triggers when you look at an insuring clause in a professional indemnity policy, you need a breach of a professional duty. Those policies are purchased by people from established disciplines or established professions, so engineers, designers, town planners, surveyors, architects, quantity surveyors, where there's an established body of study or discipline behind their profession. And the courts have pushed back on trying to expand the definition of a professional beyond that sphere. Chubb and Robinson is a case that Chubb ran to they appealed to the full court of the federal court last year. And they were trying to argue that project management is a recognised discipline and therefore should be a profession. And the trial judge wasn't persuaded by that view, nor was the full court. So it really is quite a confined type of cover available to a certain type of professional. General liability, on the other hand, is what it sounds like. It's for general liability, so they don't need to be professional in nature. In a construction sphere, I guess you would see your design engineer would purchase a PI policy, your builder would purchase a GL policy. GL policy sometimes also referred to as a public liability policy. A GL policy has a professional services exclusion on it. The reason for that is that if you are a design engineer and you purchase a PI policy, you will usually also purchase a GL policy. And the purpose of that exclusion is to make sure that the two covers sit neatly next to one another, and that you don't have double the cover between the two policies. The other thing as well is that the other reason for that exclusion is, let's assume a builder has a GL policy and they go beyond the scope of their building work and start giving design advice. The insurer's not going to want to pick that up, and they'll rely on that professional services exclusion. So that's generally the two policies that I'm guessing you guys are seeing in the market, and that's why they're different and that's how they intersect. Elizabeth spoke about the fact that the proportionate liability regime arose largely in response to an insurance crisis. Insurers were just, I guess, pushed to their limits when they're picking up, if you've got an accountant that's 20% responsible for a loss and they're picking up 100%, that's not sustainable, or that at least was the position of the insurance industry. And so insurers are pretty keen right now to only insure insureds who are limiting their exposure to their liabilities at common law. If an insured is desperately keen to go out into the market and assume liabilities above the common law, the general position is that the insurer doesn't want to pick those up, won't insure those, and the insurer will do it by virtue of an exclusion for assumed liability. And I'll show you what one of those looks like on the next slide. The construction space is a little bit different. So contractors and construction professionals are, as a matter of course, in their day-to-day dealings, required to enter into contracts. A lot of them have indemnities. You wouldn't be able to sell a policy, I wouldn't have thought, to a builder that has an assumed liabilities exclusion in it. It would just be of not much value to them if their clients are requiring them to give contractual indemnities on a regular basis. So an assumed liability exclusion, it can take several different forms, but it's pretty stock standard. It's in almost every wording. So it will be in a GL, it will be in a PI. It's pretty standard unless you move into kind of specific design and construct policies where that is just totally offensive and you'd never see that exclusion. But the exclusion is essentially, we, the insurer, don't pick up any claim against the insured arising from any duty or obligation which you assume pursuant to a contract, such as a warranty, guarantee, indemnity, unless the insured would have incurred the liability in any event. So if what's alleged against you is that you breached a term of the contract requiring you to exercise reasonable skill and care, you're sweet. That exists at common law, and so the insurer can't decline to cover you. If you agree to a contractual term that the work that you perform will be fit for purpose, you're going to run into some trouble in that exclusion, because we, acting for the insurer, will say to you, we'll cover you to the extent that you're liable at common law, but because of that fitness for purpose term, you've got that extra bit of exposure, and we're not going to pick that up. And that's what we call the gap, kind of like the Medicare gap, slightly different. Can be worth a lot more than the Medicare gap. So I thought it might be helpful. I don't know if you've had any cases where you've had that gap between, I guess, the insured liability and that uninsured exposure. We do see it quite often. So I'll just talk you through how an insurer deals with the gap, and it's different. It's different in New South Wales or states where contracting out is permitted, and then it's Queensland is its own special beast. And I practiced in Sydney for 5 or 6 years before I moved back to Brisbane, and I had to completely revise the way I was making indemnity decisions, or the indemnity advice I was giving. So in New South Wales, where contracting out is permitted, an insured is entitled to expose themselves, or they're able at law to expose themselves to a greater contractual liability. They're allowed to do that. You want to go around entering into contracts and picking up extra liabilities? Be our guest. You're allowed. The law lets you do it. So you're creating for yourself a gap. If you have one of those exclusions on your policy, that gap is uninsured. We will decline cover. We will do it pretty quickly. You'll get a letter saying you're covered for all the common law causes of action against you. You are not covered for that fancy extra thing that you gave to get the contract in the first place. And that can dovetail into a whole bunch of tricky things like allocation of costs between insurer and insured. So the insurer has to pay for defence costs under the policy. How much of the defence cost do they have to pay for? 100%? We have some insurers that will say, well, I think that if you hadn't signed up to that fitness for purpose warranty, you'd only be 60% liable. And therefore, I'm happy to carry 60% of the cost, but you need to chip in the other 40. And that number is pulled out of the sky. So we don't know what's going to happen at the level of a trial in 2 years, 3 years. So there's a certain amount of kind of good faith argy-bargy that happens between an insurer and insured to get to a place where we're comfortable with the allocation exercise. And sometimes you have an insurer that doesn't have any money, and then the insurer just has to pay for everything, and no one feels sorry for the insurer, ever. So that's what happens in New South Wales. In Queensland, it's really different though. In Queensland, if someone gives, I have a case at the moment where a council contracted with a civil contractor to build a pipeline, and there's something wrong with the pipeline, allegedly. Elizabeth told me to say allegedly. The pipeline is allegedly rubbish. There's design problems, there's rust, there's corrosion, there's wrong product. It's all terrible, very terrible, allegedly. But my insured, so our client gave a fitness for purpose warranty. So the council's suing them for negligence, for TPA, so misleading and deceptive conduct under the ACL or the TPA, and they've also got a claim against them pursuant to the warranty. If I was in New South Wales, I would say, hey, I'm happy to cover you for negligence and misleading and deceptive conduct, but you're not covered for that fitness for purpose warranty. But guess what? In Queensland, contracting out of proportional liability is forbidden. So I can't really rely on that fitness for purpose term against the insured to exclude cover, because they'll just say to me, oh, that fitness for purpose term, you mean the unenforceable one? They're not allowed to contract out, and therefore they can't possibly, at law, on its face, subject to all the uncertainty, have exposed themselves to a greater liability under the contract. So I can't rely on that exclusion against them. Does that make sense? Kind of. So in Queensland, insureds get a good run on indemnity because no insurer is sure what's going to happen at trial. Coming back to what I was saying before, assumed liability exclusions, sure, they're in standard wordings, but a lot of construction professionals and contractors won't wear them. They'll have a clever broker, or they're sophisticated enough themselves to know that that type of exclusion in their policy is not consistent with how they make their bread and butter. So they will push back on insurers and request different types of wordings or different types of policies. So I've written there, the insurance market has responded with amendment to standard wording. So that's where you keep your contract as it is, you have a play with the wording, or in expanding the insured risk. That's where you put your standard contract aside and your contract of insurance aside, and you start to look for a more kind of tailored approach for that risk. So one of the ways that you can amend the wording, one of the ways it's often done is delete the exclusion. So delete it so that simply you trigger the insuring clause, there's a claim against you for civil liability, bingo, you are covered, and it doesn't matter whether it's a contractual claim or a tortious claim or the cover's there. The other way that it can be done is simply to pare back the exclusion, and that's done by amending the exclusion. The first part is the same, so the policy does not respond to any contractual liability to which you expose yourself, except if you entered into that contract in the usual course of your business. So as long as you're staying within the bounds of your usual business, you're safe and you can enter into any contracts you like because the exclusion's been pared back. If you're a geotechnical engineer and you start entering into contracts for town planning advice, I reckon you might run into some trouble there, but you probably wouldn't be within the policy cover in the first place. The other way that you can change the wording is leave the assumed liabilities exclusion in there and you start putting optional extensions onto your cover. When an insured applies for insurance with an insurer, they're given like a quotation form or a proposal form, and there's usually a question there that says, do you want cover for contracting out of proportionate liability? And most people tick, yes, I do. And that would obviously be more in New South Wales, but insurers don't really tailor their proposal forms. They'll ask you that question, across any state. If you tick yes, you will get the first optional extension. You won't get it for free. There'll be an increase in your premium, but essentially it writes back in the cover excluded by the assumed liability exclusion. It says, that exclusion will not apply where the insured has agreed in writing with the principal to contract out of the proportionate liability regime. Now, you're not going to get an insured having that term in a contract in Queensland. I wouldn't have thought, but you might see that in New South Wales, and you might want to be covered for that. The other optional extension that we see sometimes is a more generic one. So, that exclusion does not apply because we will indemnify you against any claim for civil liability which the insured incurs under an indemnity or a hold harmless term of a contract. And that's really useful for, a builder who's entering into contracts on a day-to-day basis. They contain lots of indemnities. You would want an extension like that. There's also a specific extension for novated designs, so where a builder picks up liability for a design that was undertaken by somebody else. They do that pursuant to a deed of novation. In the usual course with the exclusion there, the insurer would say, you're not covered for any claims relating to design, because the only reason you're on the hook for design is because you entered into a deed of novation. But you can buy cover for that. You can have an optional extension that gives you cover for novated designs. Expanding the insured risk. So this is where we move away from, tailoring specific wordings of policies, and we start to look at, do I need different cover altogether? And where we usually see this arise, and I'm sure you will see it in your practice, is where clients are required to buy insurance for other parties under their construction policy. So we see that quite regularly. If that's the case, if you've got a client that's required to buy insurance for other people, it doesn't work to leave the policy in the name of the insured and fiddle with the wording. You need a new policy, a different type of policy. So it requires fundamental changes to the cover. There's a few ways in which we see it happen. You can add say you're a easy example, head contractor required to indemnify principal. We see that all the time. You can add the name of your principal onto your policy. That can be done by endorsement during the policy year. Or if you've got, if Sydney Water's a big client, you're contracting with them all the time, you might, at inception of cover, insist that Sydney Water's an insured, and you'll pay for that privilege too. The other way we can do it the other way that people in the market do it, is they add generic cover. So the policy covers the insured, but also all principals and all subcontractors of the insured. Really, really broad. I've written sometimes blanket, so sometimes it just says we'll cover all subbies, all principals, full stop. Other times, and more often than not, it will say we'll cover all subbies and principals to the extent that you are required to insure them. And that kind of involves a match between the policy and the construction contract. You've got to go look at the construction contract and work out what insurance did my client agree to give, because that's what they bought. And so the obligation to insure under the construction contract informs the extent of the cover under the insurance policy. You can't read or make sense of one without the other. And the other thing you can do is add specified contracts onto the policy. So, we see that where you're dealing with project-specific insurance, you might have an insured that's covered, and underneath they list 5 or 6 different contracts associated with a particular infrastructure project or something like that. We've spoken a bit about gaps in cover created by the extent to which you assume extra obligations under a contract. But there's actually another way that you can expose yourself to uninsured risk that is not about assuming extra liability onto yourself. It's about releasing other parties from liability to you. So, for example, if, first it's relevant to understand that when an insurer, and I may be preaching to the converted here, but when an insurer indemnifies you for a claim, they acquire at law, and usually pursuant to the policy wording, your rights of recovery against any other third party. So they're subrogated to your rights. I always find it useful to think of the insurer standing in the shoes of the insured. They basically become the insured. We get to prosecute claims in the name of the insured. We get to seek recovery, full recovery of the loss, as if we were the insured. And so you won't be surprised to learn that insurers aren't particularly taken with people that are giving away those rights at a contractual stage. So, one way you might see it is if you're contracting with someone and you've provided a release against any future liability, that's a complete waiver of the right of recovery. Probably a less extreme way that we see it happen is that someone will cap their liability. So we had a matter a little while ago which the Australian consulting engineers' standard terms were used, and there was a limit of liability. So the engineer capped their liability effectively at $3 million, which is nice for the engineer to have that capped at $3 million. But when you receive a $20 million claim and you'd like to sue that engineer and you find out that, 4 years ago the insured agreed to cap that liability at $3 million, the insurer will limit the indemnity available under the policy to $3 million because you've prejudiced its rights to get any more money out of that design engineer, or actually out of that design engineer's PI cover. So how insurers protect their rights on this issue is they typically put a subrogation clause within a policy saying, we'll indemnify you if you get sued because one of your subbies did wrong, but only to the extent that your recovery rights against that subbie have been preserved. So provided that the insured rights of recourse against such subcontractor or consultant are not waived or otherwise impaired. And we do see people fall foul of that if you're agreeing to limit financial liability. On multi-party policy, so where I talk about, if you've got a policy that covers the insured, all principals and all subbies, subrogation becomes less of an issue because the insurer can't go around suing its own insureds. Often you see it's a waiver of subrogation clause on a policy where it's got multiple insureds, which says each party comprising the insured is considered a separate and distinct unit, i.e. they're each separate insureds, and the insurer waives all rights of subrogation or action which they have or acquire against any such party. So if the principal receives a claim under that and that policy responds to it and it's for design, on one view, that principal should be able to sue the designer. But if the designer's on the same policy and the insurer's trying to take those recovery rights, they're of no use to that insurer because the designer, the principal, they're all on the same policy. You're picking it all up anyway. That's kind of it for gaps in cover. So understanding the types of policies that are there, the way in which you can create a gap for yourself if under a contract you're exposing yourself to greater liability. Understanding that in Queensland that's a bit fraught because are you even legally allowed to do that? Probably not if you look at Section 7, subsection 3. And I guess the key lessons, and they may not be lessons, they may be issues that you struggle with or grapple with every day of the week. But I guess when you're drafting a contract, are any contractual terms potentially unenforceable because they offend Section 7 sub 3? Do any contractual terms have the effect of waiving or impairing your client's recovery rights? That's easy. They will stand out to you. You will know when you're effectively giving away recovery rights in a contract. And what are the insurance implications? And the big one there is if you're dealing with a construction contract and your client is undertaking to procure insurance for one party or a bunch of other people, you'd probably want to be having a chat to the client or their insurance broker to make sure that they've got the insurance set up behind them. So making sure that they've got some of those specific policies that provide cover beyond just them. Back end, that's the litigation side of things, which is, I guess, where Elizabeth and I work mostly in that space. And they're the two questions that she outlined before. Whenever we receive a construction claim, we immediately look at, are the claims against our client apportionable? So for the allegedly defective pipeline, we look at whether or not the negligence was alleged against us, TPA was alleged against us, and also that fitness for purpose warranty. But we've written back to the other side and said that fitness for purpose warranty is unenforceable in Queensland. They've asked us for an authority. There is not one. We may just not respond to that letter. Sorry. So there's no authority on it. So we've just asserted it. Well, your fitness for purpose term, I understand that it seems very useful to you, but we say it's unenforceable. And it's wonderful for us because we get to say, well, you go sue the designer, because all the claims against us we say are apportionable. You go sue the designer. And the council's a bit stuck because they kind of feel like that fitness for purpose warranty against us should get them some traction with us, but because of Section 7, I guess they don't know, and so they've had to sue the designer. Great news for us. Another policy on the hook. And the second question is, it's the same question. Are any non-apportionable claims based on a contractual term which offends Section 3? So that fitness for purpose warranty, I think it does offend Section 7, and so I'm saying it's not enforceable.